The next case set for argument is Christine Winrod versus the City of Lorain. It's case number 19CA011503. Both sides are represented by counsel. Each will have 15 minutes to present your oral argument. The appellant may reserve up to 5 minutes for rebuttal. We do record our oral arguments and post them on the court's YouTube channel, so we ask that you keep your voice up and stay at the podium during your argument. We've read the briefs and we are ready to proceed if you are.
Thank you, Your Honor. My name is Richard Hamza, and along with my co-counsel, Tom Feudo, we represent the City of Lorain, the appellant in this case. I would like to reserve 5 minutes for rebuttal, unless the court has 15 minutes of questions. And then I would prefer to answer all of the questions rather than come back and try and do that on rebuttal. Simply stated, it is the appellant's position that reversal of the certification of the class is warranted on two major grounds. The first is that the record suggests that the court failed to conduct a rigorous analysis of the prerequisites of Civil Rule 23 in granting certification, and that alone requires reversal. There is, however, another very strong grounds, and that is that the class identified and defined is ambiguous, and it cannot be ascertained by any administratively feasible means. Now, of course, Cullen versus State Farm indicates that a rigorous analysis of the prerequisites of Rule 23 is an essential ingredient in class certification. All the cases I read really didn't define rigorous, so I actually had to go to Webster's Dictionary to look up the term rigorous. Rigidly precise, thoroughly accurate, or exact. That's the definition of rigorous. And of course, the Cullen Court requires each prerequisite be satisfied. The burden is on the appellee, in this case the plaintiff, to submit evidence to the court establishing each respective element. And I believe this is particularly important, compliance is not presumed as a result of the allegations set forth in the complaint. A review of this record suggests there is no evidence that establishes any of the elements required under Civil Rule 23. And the evidence suggests that no rigorous analysis was done. For instance, there is no hearing, not necessarily fatal on its own, but we now know that there couldn't have been any evidence entered in the record through a hearing. There is actually no evidence, nor does the court address itself to the fact that the plaintiff is a member of the class. Nowhere will you find that in the court certification of the class. That alone, as this court pointed out in the 2012 Mazingo case, that alone can reverse the class certification. But there's more. There's no evidence of the number of members in the class. And there's no evidence that the representatives can adequately represent the class in general. Now, we've made a lot of the fact in our brief that the plaintiff submitted an order to the court, and the court cut cut and pasted that order in its class certification. Again, not necessarily a problem if in fact there is significant evidence in the record which supports it. But there is no evidence in the record that supports any of the conclusions made by the court in that cut and pasted order. We also know that the court, 2 months after the record reflects the death of the Representative Winrod, nonetheless appointed Ms. Winrod Camillo class representative. Now, if that doesn't suggest to the court the failure of a rigorous analysis of the evidence, then I don't know what does.
Not necessarily fatal. Would you agree if the court's analysis otherwise was proper?
That's not, you're absolutely right, not necessarily fatal. Many times, death occurs, the court proceeds as if it did not until it's so notified that a death occurred, and then it makes the respective correction. The thing that, the point to be made here, Judge Teodosio, is that this occurred after the record reflected, 2 months after reflected the notice of death. And my only point here is that how could the court have made a rigorous analysis of the evidence and not pick that up? The definition of the class in this case, there are two definitions, of course, the class and the subclass. But the common element in both is the use of the term ratepayer and those charged under Municipal Ordinance 913.305, Lorain Municipal Ordinance, as of May of 2012, excuse me. The problem here is that there is no administratively feasible way of matching the ratepayer with the individuals charged. The first class represents all of those outside the city of Lorain. The subclass only represents those residing in a subdivision known as Hidden Valley. There are no metes and bounds associated with that definition. It's very broad. And while we may conjecture that ratepayer, although undefined, may be somebody paying the sanitary sewer rate, there is no way to determine if that person is the same person being charged, because the charge goes to the residents. You don't know whether the house is being rented. You don't know whether or not the individual is living there. There is no administrative way to match it up. And there's certainly no evidence in the record that would give you any indication as to how that's to be done. And of course, as we know, identifiability, ascertainability are the key elements of defining a class. Otherwise, you don't know who's in the class, you don't know how many are in the class, you don't know whether or not the representatives are common to the class. You simply can't determine the class if you can't define who the ratepayer is, and if you cannot match the ratepayer up with who is being charged the particular fee or rate. So we believe the definition of the class is ambiguous and cannot be ascertained. And of course, ascertaining the members of the class is as important to the defense or to the appellant as it is to the appellee, because if in fact you have to go through the class certification process or the class process itself and actually try the case, you want to be sure you've gotten everybody in the class, so you don't have a series of repetitive litigation after, in fact, the adjudication arises. You want to make absolutely certain that whatever the court decides, whatever the jury decides, or whoever decides, it applies to everybody. You want the problem to be over. There are
You're
also,
about,
I'm sorry.
You're about 20 seconds away from your 5-minute mark.
Okay, thank you. I'm almost done.
Okay.
For like 10 minutes. As we point out, the plaintiff asks for equitable relief. We believe that is something that should be addressed under Rule 23b2, not Rule 23b3. And we believe that all of the failure to have a rigorous analysis, the ambiguity of the class warrants that this class be sent back to the trial court for further review. And I'm only going to make one last point. Even if this court feels there are ways to correct the definition of the class, under Stanco you can't do that. You have to send it back down to the trial court for it to be done. Thank you for your patience.
Thank you. You'll have 4 minutes and 18 seconds for your rebuttal.
Thank you, Your Honor.
You're ready with you. Okay, counsel, you'll have 15 minutes.
Morning, Your Honors. May it please the court, Stephen Bozak on behalf of the class in this case. And I think the city's arguments in both today and in their briefing can correctly be characterized as arguing form over substance. Now, you've heard a lot about the trial court copying and pasting from proposed orders submitted by the parties, or you've heard about kind of an argument that there's no evidence without any indication of what evidence is missing. And which has led the city to argue that the trial court had no rigorous analysis. But what you didn't hear from the city is an argument of what analysis is missing. You didn't hear the city identify any individualized issue that precludes class treatment in this matter. You didn't hear the city dispute that there are several hundred households in the Hidden Valley subdivision. You didn't hear the city dispute or present any conflict that would preclude the class representative in this matter from serving on behalf of the class members. So, frankly, you didn't hear any substantive argument related to class certification here. And that's because the city cannot reasonably dispute that class certification is appropriate. And so when you can't dispute the facts, you attack the process. And so the city's main argument is that they make a big deal about how the trial court has copy and pasted and that they haven't conducted a reasonable or rigorous analysis without identifying the issues.
I guess my concern is there was no hearing here, so what evidence was there that was presented on the 7 factors under Civil Rule 23? What did the court have before it could base its ruling on?
Well, I believe the city had, or the court had, the allegations in the complaint that were not rebutted by the city. If you go through the city's briefing, both at this level and at the trial court level, you won't see any efforts by the city to rebut the evidence presented in the complaint, namely that the class representative in this matter, Ms. Ashley, resides in Hidden Valley. There's no dispute from the city that she lives in Hidden Valley and therefore can represent that class. You've seen no real efforts by the city to dispute that the Hidden Valley subdivision is several hundred households. You see no reasonable dispute from the city that there are common issues here. And I think that's important, is that when you look at the core complaints here, this is a class of individuals challenging the rates that are imposed upon them by the city of Lorain. it's a central claim of misconduct, namely that the city, in setting their rates, set them in a way that violates Ohio law, or for the subclass, that violates a agreement that applies to the entire class. And so I think it's important to refocus the core issues here, which were that there is a common claim shared by all the class members that the city's rate structure applicable to them violates Ohio law. And that is the common core claim, both legally and factually, that predominates here. And that's the fundamental focus of any class certification analysis. And so, and you can look at the city's own briefing to kind of highlight that. If you look at the factual allegations in both their opening brief before this court and the reply brief, you'll see a statement of facts that the city says are relevant to this complaint, or relevant to this certification decision. And each one of them is a class-wide issue of fact, namely how the city arrived at its rate structure, how the city alleges that that rate structure is just and equitable, and the city's summation of the Gargis agreements, which Gargis in this matter is the developer that built the Hidden Valley subdivision. And so when you look at the Gargis agreements, it's difficult to understand how the city can now argue that Hidden Valley is an ambiguous term, because the city entered into not one, but 3 contracts with Mr. Gargis, and each of the contracts includes a provision where the city acknowledges that this agreement shall only apply to the area known as Hidden Valley and those areas contiguous to the Hidden Valley development, which is hereby made part of this agreement. So it's difficult to see now how the city can argue that it doesn't know what Hidden Valley is when it entered into contracts where Hidden Valley was made a part of that. And the same goes for the city's now difficulty with the term ratepayer. They make a lot of hay of the fact that ratepayer is not a defined term within their ordinances and their rules and regulations. But another term that isn't defined in their rules and regulations is the term rate. Now that's because the term rate, just like ratepayer, is a commonly understood term. It's not something that is difficult to understand. And so I don't believe the city's arguments related to identifiability can be taken seriously in light of the commonly understood terms that make up the class definition. And I also want to address a point raised by the city related to Ms. Camarillo's appointment as class representative following her untimely death. Now, unfortunately, Ms. Camarillo passed away between the time the briefs were submitted to the court and the court actually ruled. Now, whether or not the trial court erred in appointing her as class representative, that doesn't, or that shouldn't be grounds for striking the entire class certification decision, particularly where this class action is kind of your tailor-made class action. And there's also, Rule 23 provides a mechanism for removing a class representative or striking other class allegations that are no longer valid. If you look under Rule 23D, that allows the trial court from time to time to make orders, either striking a class allegation or amending class allegations as it's needed throughout the process. And so the proper procedure here to remove Ms. Camarillo as a class representative is a motion, whether sua sponte by the court or offered by the city, to remove her as class representative. In this case, there is another class representative who will kind of pick up the ball, so to speak, and continue to represent the class in this matter. Now, I want to reiterate kind of the straightforward nature that this class action presents. At its core, again, this is a class of individuals that are charged the same rate structure, and they are challenging that rate structure. A singular issue by the defendant in setting its rates and imposing those rates on them. A singular issue, a singular issue of misconduct that an entire class is challenging. And I think it's also important to note that this is the class members' only means of recourse. These individuals are located outside the city of Lorain. They cannot telephone their congressman or their council member and complain about the rates. They can't vote their council member out. This is their only means to challenge the rates that are imposed upon them by the city. And so that's what they did. They banded together, they filed this lawsuit. And when they presented these class issues before the trial court, the trial court properly certified that class. And I believe that decision should be affirmed. And I also think it's important to, again, remember here that this is not a de novo review. This is an abuse of discretion. This court does not challenge the trial court's factual findings. They don't submit their own judgment in place of the trial court. What's required here is more than that the trial court's decision was wrong. It has to be arbitrary. It has to be unconscionable. That is a much different standard than your typical de novo review, and I think that's important to keep in mind. The trial court's discretion in this matter should be upheld. And if there aren't any further questions, I believe the trial court's decision can be upheld and it should be affirmed.
Okay, thank you very much for your argument. Counsel, you will have 4 minutes and 18 seconds
Yes, sir.
for rebuttal.
First of all, it's not the city's burden to do anything. It's the plaintiff's burden to prove by a preponderance of evidence each and every prerequisite of Rule 23. Judge Teodosio, you asked about the evidence. There are two depositions. There is the deposition of Mary Garza, the former head of the utility department, and there is the deposition of the former mayor of Lorain, Rittenauer. The only thing those depositions establish is that 913.305 was imposed upon everyone who resides outside of the city of Lorain. Nothing else was established by those depositions. There are two other affidavits, both by one of the attorneys for the plaintiff. The first establishes that he has qualifications to be a class action lawyer, so that's really not relevant here. And the second is that he gives you a picture of Hidden Valley with no legend. You have absolutely no idea what the picture represents, but he gives you the picture. That's it. That's all of the evidence in the record. There is nothing else.
Are the Gargas agreements in the record?
Yes, the 76 Gargas agreement is in the record, and I think there's a 78 and 79 agreement. But understand, there was no Hidden Valley when those were signed. That was a developer's signature attempting to bring water and sewer rates to a subdivision that he proposed developing outside the city of Lorain. So, in 1976, the city had absolutely no idea whether or not there even would be a Hidden Valley subdivision. So the existence of the 76 agreement lends nothing to the argument of certification. And a major point here, the suggestion that a rigorous analysis has not been conducted is an abuse of discretion. That's the standard. It's an abuse of discretion. Class certification requires evidence, not a wink and a nod. Gee whiz, we all know everybody's there, and everybody in town knows what these rates are. It requires evidence. And there's a failure of that evidence. In this case, it requires reversal. If the trial court wants to give it another shot, it certainly has the opportunity to do that.
So you would have us remand for a hearing on that issue?
I would have you remand on the grounds that there was no rigorous analysis. It was an order of the court to conduct a rigorous analysis and redefine the class. Plaintiff has the absolute right to do that.
But that's
And when
not,
I'm sorry.
that sounds like a de novo review, because
I'm sorry?
it sounds like your argument really would be a de novo review, wouldn't it? Because the court has no discretion not to perform a rigorous analysis.
The court has, you mean the trial court? We're talking about the trial court?
Yes.
Trial court must perform a rigorous analysis, yes. And if it fails to do so, it can't certify the class, just that simple. In this case, it failed to do so, so the certification of the class should be reversed. What the court chooses to do upon remand, what the plaintiff chooses to do upon remand, is up to the plaintiff and the court. But when you reverse it and send it back down, it gives the city an opportunity, because I assure you, we will refute any new definition. We will fight the certification of the class on down. But under Stamco, what I'm saying is that this court can't make those changes. The trial court must. Does that answer your question?
Well, I heard the class counsel indicate that our standard of review is abuse of discretion. And then I heard earlier in the rebuttal, you say the words abuse of discretion, but then the trial would then say, well, there was no rigorous analysis, so in response to Judge Teodosio's question, that this court should send it back. That sounds de novo to me. This court's standard of review de novo. Am I not, I don't want to make
My
an argument
point, no, my point is only that if you, in fact, find there is a suggestion that a rigorous analysis was not conducted, courts have held, the Ohio Supreme Court has held, that constitutes an abuse of discretion. I'm defining for you, I disagree with his definition of abuse of discretion. I'm attempting to define for you what I believe is the true definition of abuse of discretion in class certification cases.
Thank you.
Thank you.
And with that, your time is up. Thank you both for appearing today and presenting the court with these arguments. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail each of you a copy of the court's decision on the day it is released, and the opinions are also posted on the Supreme Court of Ohio's website, which I'm sure both sides know. Again, we appreciate the argument, so thanks for being here today.